Hi, this is Jonathan Ginsberg, and today I'd like to talk to you about a topic that comes up quite a bit in my disability practice here in Atlanta. And the issue has to do with part-time work. As you know, Social Security disability is dealing with a lot of very, very long delays in the management and the handling of cases. It's not uncommon for cases to be pending in the Social Security Administration for 2, 3 years, sometimes even longer. And of course, when you're waiting 2 or 3 years to get to a hearing, it can be very tempting to try to go back to work. And certainly if you can work, you should. However, as a practical matter, I think it's important for you to realize that part-time work makes it much more difficult to win your Social Security case. The simplest explanation would be this, that judges, when they see part-time work, the first inclination is, well, if this person can work part-time, maybe if they really, really tried, they could work full-time. Or if they're working a job that requires a certain level of physical activity, the natural thought is, well, if they took something a little bit less strenuous, they could probably do it full-time. I really think that part-time work muddies the waters, and I like to say that Social Security sees disability as a black and white thing. Either you're disabled or you're not. And part-time work tends to blur that distinction. And again, judges sometimes, if they're confused about whether or not really you're disabled, they're less inclined to give you the benefit of the doubt. And it really shouldn't be that way, because I think that people that are trying to work really show credibility, because they're really trying not to get on Social Security. They're trying to support themselves, but it just doesn't really seem to ever work out that way. Now, I will tell you that unsuccessful work attempts, and that would really be defined as any work attempt that lasted, let's say, 3 months or less, judges do see unsuccessful work attempts as good evidence that you're not able to work full-time. So I don't think there's a problem with trying to work, but I want to warn you that once you get beyond 3 or 4 months, then it starts to look like a regular type of job, and that's when a judge might be inclined to deny your case. Now, a couple of strategies to keep in mind about this. The definition of disability is that you are unable to engage in substantial gainful activity because of a medically determinable condition that has lasted 12 consecutive months, or is likely to last 12 consecutive months, or result in death. So I've had some cases where somebody might go back to work, but I'll tell them, if at all possible, wait until after 12 months has elapsed, because if they go back to work, let's say in month 14, that might give them 12 months, so we could always go for a closed period of disability and get that lump sum. It wouldn't give them ongoing benefits, but at least would give them 12 months. So I guess the big picture here is, if you're thinking about going back to work or trying to work and you're represented, call your attorney and talk to him. The one thing that we don't like to see as attorneys is finding out the day of the hearing that our client has attempted to work and has earnings of several $1,000s during the last couple of years while the case was pending before Social Security. Judges have access to earnings records, so they can see if you've tried to work, and they can see that you were able to work. And if we see $15,000 or $20,000 of income during that 2 or 3 years before the hearing, it's going to have to be explained. And as I said, it's very difficult to explain away part-time work that generated $15,000. It's not a lot of money, but it looks like regular work, and it makes it much more difficult to win your case. So big picture here is that there's nothing wrong with trying to work, but if you do, you certainly risk getting ongoing benefits. And if you are thinking about going to work, it's wise to consult with your attorney first to get a sense from him or her as to whether or not that's going to make it difficult for you to pursue your claim for disability benefits.